Sometimes a court might leave the courtroom and go to the places where the events in dispute actually occurred. When the court does this, it's known as a view. Under the Uniform Evidence Act, a view is a type of evidence. So things observed during the view can be considered in the same way as any other evidence, and counsel for both sides can make submissions. Under the common law, though, which still applies in Queensland, a view is not evidence. In the common law jurisdictions, a view is allowed, but it's only allowed in order to help the court understand the actual admissible evidence. Scott had the concession to show movies 2 nights a week in the Numurkah Town Hall. The same building included a supper room where dinner dances were held. And Scott argued that the noise from the dinner band was interfering with his patrons' ability to hear the movies. Numurkah Council offered the judge the opportunity to visit the hall. They had a movie playing in the main hall and a dance band playing in the supper room. The judge was able to form conclusions about whether the sound in the supper room could interfere with the movies. He observed that the noise from the supper room was barely audible in the cinema, but this was contrary to the weight of oral evidence which had been given in court. He ruled in favour of Scott because he had to follow the actual evidence, not the view. The matter was ultimately appealed to the High Court, which agreed with the judge. The view was not evidence and could not be treated as such. However, the High Court went further. The majority judges ruled that this was a demonstration, which went beyond being a view. They said, in addition to having a view of the premises, His Honour saw and heard a demonstration of the nature already described, and this, for all practical purposes, amounted to the taking of evidence in the suit. In the circumstances of this case, it seems to us such a course could only have been undertaken with the full consent and concurrence of both parties. From this case, we confirm that at common law, a view may help the court to understand evidence, but it is not in itself evidence, and a demonstration can be conducted, but only if both parties fully agree.